Good afternoon, everybody, and welcome to this Bonavero discussion group. I'm Kate O'Regan. I'm the director of the Bonavero Institute of Human Rights at Oxford, and I'm really delighted to invite our two panelists here this afternoon to talk to us about the topic of responding to COVID-19 or responding to thinking about human rights in the age of pandemics and responding to COVID-19. Martin Scheinin is the British Academy Global Professor, now attached to the Bonavero Institute. His research while at the Institute in relation to his British Academy Global Professorship will address the issue of the intersection between human rights and the digital world. But today he's going to talk to us, drawing on his experience in work in relation to counter-terrorism, on how we should be thinking about human rights in the mid stages, hopefully towards the end stages of this global pandemic. And what kind of methodologies we can use to monitor compliance with human rights as we go forward. To respond to him, we're really fortunate to have Jeff King, Professor of Law at University College London, visiting professor here in Oxford, who is also going to be one of the editors of a new Lex Atlas on responses to COVID-19, which will be published in open access format by OUP, with the support of the Arts and Humanities Research Council and Max Planck Institute in Germany. So Jeff has got a particular interest in exactly what it is that Martin's going to speak about, and we're really delighted to have you here as well, Jeff. So thanks very much to both of you for being willing to join us. Just to remind you that the format of these discussion groups is that the presenter will speak for about half an hour, followed by a 10 to 15 minutes response, and then there'll be Q&A. You'll find the Q&A button just at the bottom of your Zoom screen, and please enter your questions there. You can start from whenever you want. I will moderate the questions to Professor Shinen and King, and so please do ask what you can. We have quite a large number of people registered today, so we might not be able to get to all the questions, but we're sure it's going to be an interesting conversation. So thanks very much for joining. Martin, over to you.
Thank you very much, Kate. As mentioned, I have started at Bonavero Institute as British Academy Global Professor, and there's something which unites my earlier work on human rights and counterterrorism, this paper on responses to COVID, and also the British Academy project at Bonavero, namely, is human rights law as a framework, as a normative framework, is it capable of coping with major challenges of our world? And those who know my work know also that my answer always is yes, that I see human rights law as a comprehensive normative system, which, because it is comprehensive, has to have an answer to every question. Whatever happens in the world can be addressed through the prism or through the grammar of human rights law. We may like those answers, I hope, or sometimes we don't like them, but they're, in principle, there will be answers. So today I'm addressing the issue of COVID-19 and quite strongly try to focus on the methodological challenges. What does human rights law have to say about it? Can it really deal with this challenge? And what kind of methodologies will we need to employ in order to be able to assess strategies of countries, whether they are compatible with human rights. I want to mention that with us today, we have Helga Molbech-Stensig, who is my Danish PhD researcher still at the EUI, one of those I have left behind. And she's my research assistant in a little project still at the EUI on COVID-19 and human rights strategies. We have written a book chapter. I'll show it to you in a second, on which parts of this presentation are based. So these are some of the methodological challenges. When we look at the wealth of research or publications that relate to COVID-19 and human rights, we see that the quantity is abundant, but are we happy with the methodologies? That is the question. Some reports that speak the language of human rights focus on individual liberty and sometimes have a libertarian tone. And initially, as is quite natural and expected, when COVID-19 hit, human rights scholars focused on emergency and derogation and the possible abuse of powers. So that's largely an analogy with what happened with terrorism after 9/11. The lawyers and the human rights lawyers first asked the question, is there a state of emergency? How does that pose a risk to human rights? Mm-hmm. But then other human rights perspectives relate to the successes by countries in countering the epidemic itself. And here we see a recognition of the right to life and the right to health as important human rights. So in a certain sense, where the first option is libertarian, the second option emphasizes economic, social, cultural rights by looking into the positive obligations of states and how COVID-19, like a natural catastrophe, is a threat to those rights and what are the positive obligations to protect the population. And if the idea in Stockholm matrix or scoring system relates to the libertarian dimension, then the Oxford Martin School's Government Response Stringency Index kind of rewards countries for effective measures that may amount to human rights restrictions. And we see that here you can get a positive score on positive or negative score on exactly the same policies, depending what is your perspective. And Bonavero Institute has also produced in a couple of editions a report on COVID-19, which has expanded to cover a great deal of countries and their responses to the epidemic. And here, I think it's commendably good quality research that has gone into the Bonavero report. And the methodological problem I want to raise is, why does it leave a descriptive feel? It is like a stock taking, what's happening. And it can address concerns. It can also give brownie points for good practice in many countries where they have managed. And in a sense, it combines the two above approaches, the libertarian and the economic, social, cultural rights dimension, trying to be comprehensive in relation to the scope of human rights. But it still leaves, in my take, a descriptive feel. And I would paraphrase it by saying it is like a submission to the UN human rights treaty bodies by NGOs. It's kind of a shadow report, how the country is coping. And now is the task of how does the treaty body then assess normative compliance? I think this is not yet present in the Bonavero report. How do we do the normative assessment of whether all the information we have gathered entails human rights compliance or not? And there are huge challenges. One of them is there are so many unknowns. Of terrorists or terrorism, Dick Cheney famously said, there are both known unknowns and unknown unknowns in terrorism. And COVID is worse in the sense that it is a natural phenomenon. It's not, there's no human agency. It's just a little particle of dust, the virus, floating around. And of course, there are the forces of evolution, but there's no thinking or strategy of the virus itself. But still, there are so many unknowns related to how the contagion happens, modes of transmission, long-term effects, whether young children transmit, etc., which will assess the human rights assessment. When I started in March in lockdown conditions with my family here in the Tuscan Hills, looking into the numbers, how COVID was developing, including in Italy, I thought it's good to make a distinction between an emergency phase, where governments respond strongly and strictly and fast, and then what will be the so-called end game, the phase 2, where we ease up and we reopen society. And many of us thought this is how it will go, but it didn't. It keeps repeating, and it now looks that the distinction between an emergency phase and an end game is a false one. There's something else which is in the depths of the knowns and unknowns of this particular virus. Another important methodological point is that maybe even much more than in the case of terrorism, here we have human rights on both sides of the equation. And it's not that simplistic that it would be libertarians versus proponents of economic, social, cultural rights, negative obligations of the state not to interfere versus positive obligations to protect economic, social rights. It's not that simplistic, but because we have, for instance, economic and social rights on both sides of the equation. We may have challenges to right to education caused by the very same measures which are aimed at protecting health and life. So even within the same cluster of rights, and sometimes actually the same right, we have tensions between human rights, even the same human right of different people. We can say that even right to life is in that category, in the sense that that other health-serving and life-serving treatments are being postponed and are at risk when hospitals are made safe, and when addressing the epidemic becomes a priority. So it becomes also a balancing act between life and life. And finally, not listed on this slide, but I want to mention that we have big challenges related to epistemic communities, the competition. Because of the known and unknown unknowns, it's very difficult to follow the science. Politicians may say, we are following the experts, we are following the science, but what experts and what scientists? One way to put it is to say that the epidemiologists were in control of closing down societies, and now the economists have been in the driver's seat when opening up. And neither one is necessarily a human rights-based strategy. Here's the abstract of the book chapter we have written with Helga, outlining a human rights-based approach to fighting the pandemic and how it differs from populist or authoritarian responses. It came from the editors, the idea that we should compare human rights regimes against populist or authoritarian responses to COVID. And I think it worked pretty well, even though our focus is on explaining what is a human rights compatible strategy. This is a paper which Jeff King has received and which he may address in his comments. I'll run it through very quickly because the main section of that paper, that book chapter, consists of an outline for assessing human rights compliance or defining what is a human rights-based strategy. The first point addresses the populist regimes by saying failure to act is not human rights compatible in this situation. It may be the opposite of complying with human rights. And if we have the uncertainties, then point two is that one should err on the side of positive human rights obligations. That means right to life and right to health, and their protection should be prioritized when the uncertainties make it difficult to make choices. My third point is addressed to the epistemic community of economists, but also to some extent the technocratic epidemiologists. Human rights assessment cannot in abstracto be replaced by proxies. And this would mean that in some countries like Sweden, where strategies have been built unilaterally on one indicator, protecting the intensive care capacity, the consequences may have been drastic because not every life counts when intensive care capacity is in focus. Old people generally do not get to ICU, partly because they couldn't take the stress to their body, partly because they may have signed a living will, which says please don't treat. And even worse, I'd say, we have, when the economists are opening up societies, we have a dogma, which is lockdowns cause deaths as well. And that's why opening up societies in the long run is beneficial to the population and will save lives. And these kind of proxies are quite problematic. We do defend the use of internal human rights proxies, because there are some human rights which are indicative of general human rights compliance in this issue, which then can kind of comprehensively cover a whole cluster of rights, which we do a careful analysis under a specific right. I mention often right to health in the context of right to life. That's a good proxy for many economic social rights. And on the other hand, one could say that the right to privacy and freedom of assembly may quite comprehensively cover much of the scope of civil and political rights, implications upon them. Item 4 is the most important for the methodology of human rights assessment. And this is the one which is most closely related to my long-term research. When two human rights collide, the core of any human right must have primacy. And beyond the core, then there must be a rigorous proportionality assessment. And the emphasis is here on the word rigorous. Core dimensions of human rights are not subject to balancing or proportionality. They are absolute. But when there is room for proportionality, then it's not a question of abstract balancing between competing values. It is a structured analytical assessment, and it requires measuring. The proper proportionality assessment is between the proven effect towards a legitimate aim caused by a restriction upon a human right compared to the actual proven level of human rights infringement. So we need measuring. We need to measure both the benefit towards, say, protecting the health of others and the human rights harm resulting from restrictions of liberty. It's not enough to say, well, here we have a tension between health and liberty and politicians must decide. No, first we must measure both sides of the equation. 5 include all economic, social, cultural rights. Often even they are on both sides of the equation. 6, non-discrimination is an important part of any human rights strategy. 7, of course, there needs to be respect for the rule of law, which easily translates to the requirement of legal basis for any restrictions and access to remedies, including judicial remedies. Item 8 is primacy of liberty, which results in minimizing mandatory restrictions and emphasis on the importance of promoting cultural change instead of just top-down mandatory restrictions. Item 9 addresses freedom of assembly by saying restrictions of all types of gatherings are prima facie justified in controlling an epidemic. There's a presumption in favor of restrictions being human rights compatible. But in the same breath, item 10 is there must be a positive obligation for states to provide for alternative forms of exercising the rights in question, freedom of assembly, association, and expression, and religion. And this, of course, leads us to the broader question of human rights and the digital realm. How can restrictions on face-to-face gatherings be compensated by developments in the digital world? Item 11, likewise, restrictions of freedom of movement are prima facie justified, but they must be precise and well-targeted. And this relates to item 20, which is if we reduce international travel. Travel bans or closing of countries' borders are not the correct measure because they are too blunt. Rather, the measure should be based on medical expertise, tests, if need, quarantine, and effective information about those measures in order to disincentivize travel instead of introducing travel bans. Back to the list 12, acting early is human rights compliant, and therefore restrictions or even derogations are not wrong by definition. We can see in various parts of the world many success stories and countries that acted early, promptly, and decisively may have had a decisive advantage, which turns to the benefit of human rights in the longer term. 13, protect the vulnerable and their dignity and rights. There's a slogan about trace, test, and isolate, and I think that needs to be turned into trace, test, and protect dignity and rights. Do not isolate, but provide services to those, for instance, who have been diagnosed positive. 14 relates to the primacy of voluntary measures, promote cultural adaptation. It is human rights compatible, and perhaps even more than just human rights compatible. I think that a lasting lesson from COVID-19 may be the importance of voluntary cultural adaptation, where solidarity has a greater share in people's lives. In a certain sense, what we see now in the world is a battle between self-centered selfishness and altruism or solidarity, where the question can be posed, do I protect myself from the suspect other, typically the foreigner who carries the infection? Or am I the potentially infected person who might transmit the virus to others? So here clearly is a need for cultural change, which also means that human rights are not only obligations of the state, but there is an interpersonal dimension. 15 is about the same thing as 13, protect the infected ones. 16 and 17 are of the privacy dimensions, which most closely relate to my Bonavero project as British Academy Global Professor. Proximity alerting apps are not contact tracing apps, and they fail if they are used for contact tracing. They must be incentivized by guaranteeing that they are used as proximity alerts and not resulting in the negative consequences of contact tracing as such. A positive test result creates obligations related to contact tracing, but not to carrying of an app and not the message you receive from app. Reject immunity passports. 18 takes us back to economic, social, cultural rights. Staying home for the infected and exposed only works if there are labor rights and income support that do not create a situation where people, for instance, in precarious work, have to go to work even if they feel sick. 19, make means of transport safe, and that of course relates also to international travel and takes us back to point 20, which was about the borders. So if one is to apply this kind of a checklist or outline or a human rights strategy model, it results in the need to measure in order to have the proportionality assessment between the different items, which are as such in tension with each other, saying human rights are both sides of the equation. We need, for instance, human rights lawyer experts, economists, epidemiologists, virologists, public health experts, and social scientists who inter alia know what makes people comply. How can you influence human behavior? We see that long-lasting success, particularly in individual-centered Western societies, is difficult to achieve unless there is an interpersonal commitment to combating the epidemic. These are different disciplines, but I think it is important to emphasize here that it's not only that these are different opinions handed to the politicians for their decision what to do. These are also elements of the human rights assessment itself. We, now I speak of us human rights lawyers, we cannot make the proportionality assessment without having the evidence. We must be able to measure what is the proven benefit towards protecting the right to health. Only then we can say what level of restrictions of liberty will be proportionate. Without assessing the evidence on the other side of the equation, we can't say whether one restriction is disproportionate or proportionate. And here's how I think we can move ahead. These are possible baskets for a human rights strategy assessment model. There are 3 baskets, each worth 30% of a score, maximum 100, and then a smaller basket for rule of law of 10%. And there's a huge degree of overlap between the different baskets. There's also overlap between positive obligations, economic, social, cultural rights, negative obligations, civil and political rights, but those are not 100% overlaps. So that we have a 30% basket related to positive obligations and economic, social, cultural rights, a 30% basket on non-interference and civil and political rights. A third basket, equality and non-discrimination, is also 30%, and of course overlapping with the other 2. And finally, there's in the center the rule of law dimension of the issue, which includes both the requirement of legal basis for restrictions and then access to justice, access to remedies. And if we translate this to a tentative listing of the elements of a strategy assessment model, we have here the 4 baskets, 3 of them with a maximum score of 30 and the last one with a maximum score of 10. And quite nicely, each of them has 3 separate elements. And now I get back to the question of proxies. We can look at basket 1 by focusing on 3 clusters of rights: life together with the right to health, education, and adequate standard of living. If we collect comparable information from different countries, we can give them a score. How do they cope on these 3 clusters of rights? And my claim is that they would be representative of their approach generally in respect of positive obligations, economic, social, cultural rights. Similarly, for civil and political rights, 3 clusters or 3 rights: freedom of movement, which can be seen as a proxy for general liberty, autonomy of the person. Then we have right to privacy and protection of personal data, and this is a cluster of its own because of the importance of the digital realm in today's world. It's represented in my earlier slide in the proximity tracing apps and immunity passport issue, but of course there are huge privacy and data protection issues elsewhere, everywhere. And the third element in this basket is freedom of assembly in relation to gatherings, which then becomes a proxy for association, religion, and political participation, because all of those are dependent on the effective exercise of freedom of assembly, where, for instance, providing alternative online means would be a good way of getting a good score on this point. You introduce restrictions, yes, but you compensate them by positive measures. Third basket on equality and non-discrimination, there's special measures to protect vulnerable groups, obviously the elderly, those with underlying conditions, but also persons with disabilities and disadvantaged ethnic groups, for instance, who because of their family structure or their living quarters may be more vulnerable than others. Gender aspects would be the second elements, and thirdly, arbitrariness in decision-making. For instance, in allocating healthcare or ICU placings would be a third dimension of discrimination, which would be a basis for scoring on its own. And finally, the little basket of rule of law is less important weight-wise than the others, but it's a good check for human rights compatibility to do the rule of law benchmarking of measures in respect of COVID. And of course, this is particularly important in countries that introduce states of emergency. Finally, the most important methodological consideration is that this is not mere arithmetics, that you add the scores together and you get a score between 0 and 100. There's also a possibility to give negative scores. And here the notion of a core of any human right is important. Because if you get a high negative score in any of the baskets, it can also cancel what comes from the other baskets. And this is my primary response to the perception that reports such as the Bonavero report on COVID-19 would unduly focus on Western countries and pick negative things from there, and not strongly enough criticize authoritarian regimes. I think there is a way to square the circle, in the sense that you give due recognition of measures even by authoritarian countries to protect the life and health of people, but at the same time you give them a strong negative score anywhere where it's due, and therefore in the end they don't necessarily get a higher overall score for human rights, the human rights assessment as a whole. So in the end, it is true that a score from 0 to 100 is possible here, but you don't get to your score simply by adding the positives from the different baskets. You will also be faced with a situation that there is a negative score from 1, which then will affect the overall count. I will stop here to give time for the commentator, Professor King, and the discussion, and I'll be happy to answer questions.
Thanks, Martin. Well, it's already spurring a lot of interesting questions, and look very much forward to hearing what Jeff has to say in response.
Great. Well, thank you. It's an honor to be able to present and respond to this paper from Professor Scheinin. I won't need to see this slide until about halfway through what I'm going to talk about. So you're welcome to take that slide down off the screen. But I will ask you to put slides 7 and 8 back up a bit further on. So I think that this project is very valuable, and I think it's extremely important to come up with something like this, something like an index for assessing human rights compliance, even though it's beset by a range of challenges, methodological and otherwise, to produce it. And the simple reason is that the range of duties that states have under human rights law, international and national, and the extent to which compliance with it can vary across the board it makes it difficult to get a picture of what human rights compliance is like just by having a catalog of court cases, of laws, and so on. You do need to have something that is a bit more methodologically rigorous. And I think that this index is an attempt to produce just that kind of thing, and it's a welcome one. So I want to comment briefly on the co-authored paper that Professor Scheinin had circulated, and then I would like to comment on the methodological points that arise here. So in the co-authored paper that was referred to in the slides, Professor Scheinin makes a range of points that were covered in the slides, and I want to stress some of the points that I agree with. I think the majority I agree with, and there were a few that I wouldn't so much say I disagree, but I would like to put some footnotes on them. So the first point that I think is incredibly important is the very first point in that paper, which is that a failure to act is not compliance with human rights, and that it may in fact be the very opposite. Now, this is an incredibly salient point. It's not a seminar room point. To illustrate that, just yesterday I had an exchange on Twitter with a barrister who is taking the main judicial review case in the UK challenging the lockdown here. And he's arguing that it violates fundamental human rights, and that the one in March and every subsequent one effectively violated human rights. Now, someone had quoted a statement that I had made earlier that made the very point that Professor Scheinin is arguing for here, that we have to look at human rights in the round that includes civil and political, as well as economic and social rights, and that human rights in general, and I would say even the right to life on its own, can impose a duty and has been held to impose a duty on the state to act. And he thought that argument was a fundamental misunderstanding of human rights. So I think it's important that we emphasize this. It's been stated repeatedly, including by Lord Sumption, a former Supreme Court judge, that the response to the pandemic is the greatest peacetime suspension of civil liberties. And I believe that this rhetoric is quite problematic. It's my view that there is no right to do something that will harm another person. That was John Stuart Mill's view as well. The question of whether human rights are infringed even is an open question. Certainly restrictions on mobility and liberty are important and they need to be justified stringently, but to say that they have been violated or that we can accept these violations as justified by the public health crisis, I think is a conceptual mistake for the kinds of reasons that Professor Scheinin is indicating. They do violate these rights if they are disproportionate restrictions, but there is not clear evidence that any of the main lockdown provisions and mobility restrictions are on their face disproportionate in that way. So I think that point is incredibly important. The second point, and I think is related, is the importance of giving social rights equally important billing in the list of considerations for assessing the efficacy of human rights compliance. And that puts things, that not only recognizes the true range of internationally recognized human rights, but it recognizes some of the things on the list in the paper of Professor Shinen, such as work arrangements in home, social policy in relation to gender, and many other things. Thirdly, the emphasis on proportionality as a standard for evaluating how to assess the, we might say, superficial or possibly deep tension or trade-off or balance between positive state duties to protect and negative state duties not to infringe rights. Proportionality enters the picture here as a way of saying when it is that an impairment or infringement of some sort isn't actually necessary to fulfill the positive duties to protect or respect the right to health or the right to life. And so the concept of proportionality comes into the picture as a way of testing whether the restrictions are genuinely for the purposes of protecting social rights and not as some sort of trade-off between rights. So I think the emphasis on proportionality is quite important. And fourthly, and my last point in terms of strong agreement with the paper, is to recognize the importance of equality and the need to give special treatment to the most vulnerable groups, as well as for cultural adaptation, what we might call reasonable accommodation. This is the real forte of human rights thinking. It's giving equal respect and concern to all persons in society. And it's something that, in my experience, public health officials and governments more generally are less good at doing than human rights. People who work in the area of human rights. We're thinking of those people, and that's what we bring to the table. Now, there's a couple of points that are covered in the paper that I wanted to probe. The first is that there is a question about how the various points made in the paper fit together. So, for example, it's argued that persons should, quote, err on the side of positive human rights obligations, on the one hand. So err on the side of positive rights, that is, take action. And then later, it is asserted that we should have it, the primacy of liberty should be restricted, i.e. minimize mandatory restrictions on the other. Now, to me, this sends mixed signals to an extent. If you, as a public health scientist advising government, you see the restrictions imposed by public health measures precisely as fulfilling the right to health and security for the right to life. And so I think it needs to be worked out very carefully how the primacy of liberty, as it's put, and erring on the side of fulfilling duties in respect to the right to life and the right to health fit together. And for the reasons I've already mentioned, I think it's incredibly important to be careful in that respect. Second, there were a few items in the discussion, and I'm thinking here of proximity alerting apps, immunity passports, and the rejection of travel bans that I tend to think need to be more guided by the science than they perhaps are here. It's not obvious to me. Now, obviously, a travel ban will be a violation of human rights if it just is in the abstract. If let's say it invades some core feature of privacy that no policy can justify. I accept that. But it's not obvious to me here that any of these three things do violate human rights in that way, if they are effective at doing what they purport to do. And so it really turns on the question of efficacy here. And whether these measures are effective is an open question for science. And I think that science should guide here to a great extent. States should be given a margin of discretion in deciding how much weight to give it. In fact, if anything, I would say a state that is callous and disregarding the science should be more suspect in public law terms than one that is slavishly following it. Although I think slavishly following it is also indefensible. But I'm saying that I'm less suspect of these categories than you are, but perhaps your experience in the field of anti-terrorism has made you very suspect of those kinds of intrusive measures that the state can use. Let me come on to the methodology part of the project. And here I would ask if it's possible to put slide 7 back on screen. Now, I'll just begin by recognizing that as I said earlier, the advantage of this project seems to be to provide a type of index. Oh, by the way, if you don't have the slides handy, I can always share my own screen if that would be easier. I don't know if I have the rights to share my screen.
I do have them. I just don't see that. Here it is. Here it is.
Yeah.
Share.
Okay. Great.
Coming.
Great. I'm not sure if everyone can see me still. I can see Martin on screen, but I'll assume that you can see me. So generally, the idea, as I read it and understand it, is that this is a type of index for assessing human rights compliance within national responses. And it's an attempt to inject some methodological rigor into these overall national portraits. And I think for the reasons I've already given that this is an important thing to do. Now, there are 2 methodological challenges that I see in this kind of project. And the first is to decide how you weight each of the sub-features of the scale that's being used. And here we have 4 sub-features. Let me call these categories, actually. We have 4 categories here, and we're looking at producing an index. And it's been decided that positive obligations will be given a 30% weighting, civil and political rights 30%, equality and non-discrimination 30%, rule of law 10%. Now that's absolutely fine. I would like to talk about how this is constructed in a moment. The second issue is about how you weight the determinations, the scores that are assigned within each of these categories. Now, I think in a nutshell, my view is that the setting up of these categories and having the distribution of weight between these categories, as you see it on the screen, is not particularly challenging methodologically. It can be criticized, but I'll get around to those criticisms because I don't think they're at all fatal. The second issue about how you weight and score performance under each of these categories is much more difficult, but not insurmountable. So let me get on with the first. So we have 4 categories here. 3 are given 30% and 1 is given 10%. And I believe the idea will be here that the combined score and cumulative score of each of these will give you a rough assessment of how well the country complies with its human rights obligations in the round. So if you get 15 plus 10 plus 20 plus 10, then you'll have a score of whatever, and you will fit into the scale of performance with other countries based on that score. Now, it would be easy to criticize this by saying, well, these are incommensurable factors. It can't be done. You can't trade off violating dignity with how much non-discrimination you have or how well your laws are made. I don't accept that criticism. Indices all over the world have to make just these kinds of rough judgments, and provided, and I'm thinking of the Human Development Index, I'm thinking of the many rule of law indices, I'm thinking of Freedom House. You can't do those things without those kinds of rough judgments, and they are useful in my view. You need to do something, which is that you need to define what it is you're looking at and how they're weighted into your index. And provided you do that, I think it's sufficient, assuming that the rough distribution that we see here is reasonably defensible. And I think that it probably is. What I would do in this situation is I would have some kind of workshop to explore this and to sort of rake it over the methodological coals with social scientists to see if it withstands scrutiny for that kind of thing. Now, what I do think that needs to be done here, and this is slightly more critical, is that you need to ensure that each category measures something along the same scale. So I think it would be difficult, for instance, to assign relative weight between the categories. And I think you're proposing to do this. If you're comparing good things that countries do in one category with bad things that they've done in another category. So if you're trying to compare how much the fulfillment of the right to life through an effective national lockdown with restrictions on liberty, disproportionate restrictions on rights in another category, these are genuinely very difficult to compare. I think quite impossible. So if you look to slide 8 for a moment, Martin, you'll see at the end of the slide, you suggest that poor performance in one category can bleed over into detracting from another category. So a high negative score under any basket can cancel all positive scores from the other baskets. I think that kind of, forgive the expression, but intercategorical trade-offs within the model will be very difficult. What could be done, and I think effectively, is simply that you have a cumulative score for each of these categories, a 0 to 30 performance for the first 3, and a 0 to 10 performance on the 4th, and you add them up. And you don't have to express a judgment about how much a violation of liberty detracts from the effective implementation of the right to education. And I think that is eminently defensible as an approach. Again, provided it's very transparent, the way that it would work. There will be some difficult judgments to make. Does a country start with 30 and then lose things for negative things? Does it start with 0 and you add for positive things? You can't just count up the number of new statutes that are adopted that are COVID responsive and look good, because it might be that some country like Germany had most of the legislation in place already. And so that will make comparisons. My instincts are that you should have a framework in place that is an example of a 30, a perfect score. And then you see what the incidents that constituted that perfect score are, and then you can look at other countries to see if they also have that. I'll actually say more about that in just a moment. Now, assuming these categories are kept separate, and assuming the scores are cumulative and they're not, again, intercategorical, I think this is fine. And so my first methodological concern, or the first challenge, I think could be met in pretty much the way that you're proposing to do it. Now, the second concern is more difficult, and this is the slide that we're looking at now. How do you weight 1A, 1B, 1C? Now, the ordinary way an index does this is to plug in some reasonably determinate value. So like income or Gini coefficient, expenditure, etc. Now that's just not possible here. And again, neither is it possible to just add up the number of measures, like I just said. If you've got a COVID-19 migration or a COVID-19 gender piece of legislation, or you have a new social benefit like furlough schemes that respond, if you just add these up, you have the problem that the existing provision may already have been adequate for it. So I don't think the problem is here that the categories are so radically indeterminate, although some would argue that they are. But what you definitely have to have in order to apply these is someone exercising judgment on how they should be weighted or scored. And so the question really is, by whom and how? I think in terms of how, let me just say, I think that you'd need to provide guidance to the people who will be exercising these judgments. And this is kind of back of the envelope, but that's what is done most of the time in this nation. So I'm going to do it. My sense, and this is based on my work on Lex Atlas as well, I'm thinking about it, you'd want to be giving guidance to the people applying the categories and making these judgments that will specify a very highly performing country and telling them why you think it's highly performing, those that have done abysmally and why, and those that are middle of the road. And in framing that guidance, I think a workshop on it would be very, very helpful. So then they're applying a framework and they're applying their judgment. It's less completely at the discretion of the people scoring it. Okay, but then who's going to do it? So I don't think it should be done by people outside the country, because the variables here are way too vast. It's simply almost impossible to judge how effectively a country responded to education measures unless you're familiar with the education system, you understand the social support, you see how it integrates into other social policy. And the same with public health measures like lockdowns and travel bans. They're deeply contextual, and that's going to be only something that can be understood by people essentially embedded in the system, and above all, who speak the language in the country. So assuming you're finding people like that, then I think it's difficult to rely on just one or even to two persons, because if you did, you'd be hostage to chance, that you have selection bias in the people that you've asked. And this hostage scenario is amplified quite considerably where assessments of these things are deeply polarized, and academic integrity might be less reliable than what you might expect at the Bonavero Institute or the Abo Akademi Institute in Finland. And I am not, this is by no means am I trying to be in any way disrespectful to the academic traditions of other countries. In the Lex Atlas project, we've wrestled with this issue, and the issue's been emphasized most strenuously by members of the editorial committee that come from Mexico and Brazil. And they insisted that we go with a neutral political tone to try to minimize this problem. So picking these people is going to be difficult, and it becomes more methodologically suspect if you have few. Does that mean it can't be done? Well, the World Justice Project, which has an index on the rule of law, does do this kind of thing. It has these kinds of variables. And I think that their approach is a reasonably good one. It has been criticized, but I think it's quite good. And essentially, it's to have a sample of persons within the country that is surveyed on the topic. And they combine the responses to the questions, and then they aggregate the scores in that kind of way. So I think this approach is not without its critics. It's still, you know, people could say that there is selection bias, or that the criteria are too loose to ensure that people are really answering the same kind of question. So if you ask someone, just has the right to health been complied with, without any indication of what they should consider in answering the question, you will get diverging answers even from experts. But if you indicate what to look at when answering that question, well, then the scope for disagreement reduces considerably, one hopes. This approach by going wide and polling people, experts, is one way to do this. And I think that they've done it reasonably well, but it is expensive and it requires using professional services. I imagine there might be some scope for teaming up with a body like the World Justice Project on something to use some of their data, because I assume that they have people in place on the ground that respond to these kinds of questions already, in particular question category 4 here, but also category 2 as well. So that's one way I think that that you could go about giving effect to this project, essentially, as you've conceived it here. Now, the other way to go about collecting...
Yes, sorry to interrupt, but I'm a bit anxious because we haven't got a lot of time. I mean, everything you were saying is fascinating, but we have a large number of questions. Is it feasible for you to finish up in a minute or two?
I have 2 sentences left, actually, so apologies if I've gone over time. The other way to do this kind of project is to just try to have an in-depth contextualized account of what the states are doing in each of these areas, and to use good old-fashioned scholarly judgment applied by people who are not reporting the data, but who are looking over the data, and try to make some rough judgments about best and worst practices in that way. That's the kind of approach we're trying to take in the Lex Atlas project, but it doesn't provide an index, which is a handy source of comparison for this kind of work. So I'll leave things there, and thank you very much for listening.
Thanks very much, Jeff. Those really insightful and helpful comments. Martin, would you like to respond briefly? As I say, we do have a lot of questions, which we're not going to get to all of them, but would you like to respond now?
Yes. Do I have the microphone on? Yeah. I give
maybe you should take off
three very brief comments where Jeff had critical remarks. Thank you very much for this thorough assessment, and you gave me much inspiration how to develop this further. There was the question, how do I fit together the err on the side of positive obligations and primacy of liberty. I think it can be answered, try first with voluntary conduct. If it works, it's human rights compatible, and introduce mandatory measures only when you know that people will not comply. And one main reason why I think this is valuable is that there's fatigue. There's compliance fatigue in respect of mandatory measures which haven't been internalized, and that's the emphasis on cultural adaptation. So in my view, the idea of liberty together with cultural adaptation produces better long-term benefits. So that's the nutshell answer to that challenge. And actually it's also answers to your second query about, for instance, proximity alerting apps. I think the science is there that countries that have protected the anonymity and privacy get the best compliance levels. And here we need not only the health scientists and the data scientists, but also the social scientists to tell us what creates best levels of compliance. And therefore, I'm more convinced than you, Jeff, that those items that you say are not prima facie wrong. To me, all the things considered are wrong, that they will not work because they will not be compliance. And then thirdly, to the methodological points related to the index or scoring approach. When you were speaking, I was thinking how else to operationalize the idea. And I don't think a simple addition of the different scores is a good model, because there needs to be a way to say, if you do not respect all human rights, if you get a 0 from any baskets, then you are not in human rights compliance. So you can't get full scores from 2 baskets and get a score of 60, a passing grade. And when you were speaking, I was thinking in my head that some kind of a multiplication approach might work. That if there are these 4 baskets, you would get from each of them between 0 and 2. A 0 would cancel all the other scores, and a 0.2 would greatly reduce the positive scores you get from the others. So something like this, that would combine what you said and what I initially presented. I'll be happy to hand over to the Q&A.
Should we take the slide off screen as well so we can see?
Yeah, I'll do that.
Thanks, Martin. That would be good. So we have a lot of questions, and we're limited amount of time. I'm going to try and pick up a range of them. So it seems to me, and I'm going to, unfortunately, I'll jump around. So apologies to questioners whose questions may be overlooked or joined together with others. But there seems to be a range of questions which are talking about the problem we have from the known unknowns and the unknown unknowns, to the extent that the inaccessibility, as it were, of scientific knowledge at this stage creates difficulties for any kind of assessment in circumstances where, for example, a proportionality analysis is going to be based on questions like effectiveness, which are going to presuppose an understanding of a whole range of issues relating to the pandemic. Mm-hmm. So, how do you respond to that? Does this mean we can only do this afterwards? And to what extent, in circumstances where you're trying to evaluate a human rights response now, how do we feed into this the fact that we actually can't do the ordinary human rights analysis that we would do in circumstances where we had mostly known knowns? You want
I go one by one? I'm happy to start.
So that's kind of putting together a range of questions. I can put a couple more if you'd like to do that. So the one is that. Another is that in some of your categories, take, for example, the economic and social rights categories. 1A is about the right to life or the right of access to healthcare, and 1C is about the right of access to a reasonable standard of living, i.e. it would include within it a right to work. Now, very often those two in many COVID responses are going to be at loggerheads with one another. So if you have a lockdown which prevents people going to work, for example, restaurant workers in the UK during the current lockdown, how do you deal with that? Do you give 0 for the breach of the access to a reasonable standard of living? and how also do you actually put a quantity on healthcare? I mean, should we feed into this that some countries actually have no tertiary healthcare systems, and so as soon as the pandemic gets out of control, you're going to have people who don't have access to healthcare? So some questions about both the conflict within category 1 between life and access to standard of living, and also the problems of differential responses to that across different types of states. Because really what we're trying to do with the index is produce a comparator or a method of comparison. So that's a second range of questions. I'm just trying to look at, trying to pick up some other ones. So there is another comment about weighting the rule of law as only 10, which there doesn't seem to be any weighting at all in relation to maintaining what one questioner, my former colleague Leora, talks about, epistemic communities, the idea of legislatures, the idea of institutions, human rights commissions, judiciaries, etc., that will be involved in a domestic environment with trying to think about these questions. There doesn't seem to be any weighting for that unless it's within the rule of law, and the rule of law seems quite underweighted. And if one's thinking again about illiberal states, that's going to be a situation where you know, those are probably going to be areas where there is poor results. But another colleague, Laura Hoyano, talks about the issue of access to justice and a fair trial, which, you know, to the extent that criminal trials are kind of curtailed, all sorts of issues about justice within a reasonable time, etc., may arise, and other issues of straightforward criminal justice. So that's a group of questions about weighting the rule of law only 10 points against 30, 30, 30 for CPRs, ESCRs, and discrimination. And also not potentially really writing in any or reflecting any importance to institutional mechanisms for accountability as part of a human rights framework. So should we put those three out there and see how you respond?
Three easy questions. Well, first, I do think that COVID-19 will be as era-defining as 9/11 was. This is not the last pandemic. It will shape and define the human rights discourse and policy discourse for decades to come. And unfortunately, there are many trends in the overall process of globalization and globalized development that pose a grave danger that there will be other ones. So in that sense, it's not a catastrophe for humanity that some of this work will be done only afterwards. I can't give it as an honest answer now, because of course we need to take the decisions all the time, but it's also good to say that yes, the full picture of the unknown unknowns will emerge only later, and now we have to be brave and react spontaneously, and erring on the side of caution is wrong. Erring on the side of action and on the side of positive obligations is the correct approach when there are uncertainties. So that's the quick answer. As to the second one, of the incompatibility between, let's say, 1A and 1B, yes, I think in the additions model, it's quite easy to say that you can get a score of 0 from one particular element without that greatly affecting your overall score. So I would be happy to have the addition within the baskets and then the multiplication between the baskets, where you would give due positive assessment to what the country did, and then you would give a 0 where it failed, and then only in the multiplication you would see what the effect is overall. I was involved in the project of the UN Office of the High Commissioner for the Human Rights Indicators for the treaty bodies, where there's a lot of talk about what is an indicator and what types of indicators we use. And we, for instance, see in many cases that there's a bell curve that neither 0 or 100 sometimes is the optimal situation, but it can be somewhere in the middle, and both extremes are equally bad for human rights. And then there's the issue of benchmarks. You kind of set what is the level of expected or proper compliance for a country or generally. And in that sense, I think it would be important, if we have those categories that I presented, to have for each of them a good, hopefully numerical, accessible indicator, and determine what would be the presumed benchmark. And for the category of life and health, I could, for instance, suggest that it is the level of excess deaths, overall excess deaths during the pandemic in a country calculated as persons per million inhabitants. And I could show you the graphs of different countries, how they have fared in various stages of the epidemic. And one could say that a country is in control of the situation and complying with human rights as long as excess deaths are at the range of 2 persons per million per day. This is just a statement of what could be the default grading for one of those items. Third question was the smaller basket. I was thinking that if it's of equal weight than the others, then there's overemphasis on the negative civil and political rights dimension, the very traditional liberal or libertarian approach to human rights. And I countered that by giving only a smaller weight to the fourth basket, but conscious of the fact that you could get a failing grade, which cancels then all the others. For instance, abuse of a state of emergency would cancel all the positive things you do in other baskets. But now that Jeff has helped me to think of a multiplication model, it will be easier to think of, if not equal, then closer to equal weight of the different baskets.
Yes, I mean, I think that it does also seem to me that maybe quite a lot more work on exactly what you're weighting in each individual basket might take some care. So if you look, for example, at the way both Freedom House works and VDEM, they have quite a sort of careful assessment within them, and they also rate them on a kind of 1 to 4 basis. So I can't remember if both of them do that, but that's quite a common way. So I mean, thinking a little bit more carefully within the baskets might be helpful, and even allowing a little bit of double counting within baskets might also be a possibility, so that some things within a basket may actually weight more heavily than others. So rethinking that might be useful. I'm just going back to the other question. So there was another question which was about the fact that sometimes the social, economic, and political context of a country may change the circumstances in how you weight a particular element. So the comment was, for example, talking about the control on gatherings and assemblies, and took the example of Belarus and the situation that actually for the political circumstances in Belarus, a limitation on gatherings there might in fact be a far more, particularly heavy human rights burden, which it might not be in a country which is not going through a period of intense political contestation. And that's a problem that, applies across a range of human rights questions, that context is all in allowing us to determine the significance of a particular human rights infringement in a particular time. So that's one question, that context changes. The other is the problem that actually, as we know, and as the Bonavero reports make clear, the ways in which governments are responding to the pandemic is changing rapidly over a period of time. So at what moment in time do we do this measure? Do we take an overall view of education across what may tend up to be an 18-month or 2-year period? Or do we snapshot it? And how do we deal with that problem, that there's a real temporal issue here, which doesn't seem to be fed at the moment into how you're expecting the survey to be completed?
Well, your second question is a very challenging one, and this is on the slides that I didn't show, where we thought until August or September that European countries were coping, because there was an emergency phase, and then the numbers were pressed down and they were kept down. And then one after the other, first Spain, France, UK, Italy, next week perhaps Germany, fail. And I think we human rights people, human rights lawyers, we must be able to say this is a human rights failure, because it's not a natural catastrophe when it happens 6 or 8 months before the first wave. This second wave, if you use that expression, is man-made. And that we have to be able to say why it is a human rights failure. And this results in the answer that in the end, the full human rights assessment is made afterwards. We can make a preliminary assessment, which can be optimistic and say, Italy is doing great. We can say that on 15th of August, and then on 15th of November, we have to say, unfortunately, they failed. As to the first question, Belarus, etc., I think we have a nicer laboratory, which is the United States, where we had the Black Lives Matter demonstrations and the Trump rallies. I think human rights law provides a framework, and the Human Rights Committee General Comment 37, adopted during the pandemic and adopted in an online session of the Human Rights Committee, shows the way. That how do you take into account the context when determining what is a violation of freedom of assembly, even at the time of pandemic, and what is responsible action to protect life and health by the state. So I think we can answer the question.
Yeah. Well, thank you very much, Martin. I'm afraid that we're running out of time, so we're going to have to stop here. But thank you both for a really interesting exploration of something I think we're going to go on thinking about for a while going forward, and which in fact is going to have a broader implication, I think, beyond just the responses to COVID. It's beginning to think about indexing in this field is really important. So thanks to you both. I'd just like to remind people who've attended that next week in the discussion group, we'll have Professor Sandra Wachter talking about discrimination in algorithmic decision making. So an equally important topic, and please register and attend that if that's something that interests you. And for the rest, I just like, on behalf of all of you here, to thank you all for being here and for all of your questions, and to thank Martin and Jeff for really interesting contributions. We look forward to this conversation going forward.
Thank you, Kate. Thank you, Jeff.
My pleasure.